This is a great moment for the International University College. It's our first alumni reunion after 18 years of operation as a degree-granting institution, and after 20 years, almost 19 years almost of operation as the center that established the Common Core of European Private Law that was started here in Torino when moving away from Trento in 2006 with the opening of the International University College. Therefore, it is very important for us to be all here, and also we are very grateful that we are able to be hosted in this beautiful building by the Fondazione CRT, which is chaired by my very dear friend and colleague. We were together in the faculty as students' representatives back in 1979, so there has been a long acquaintance, and she has generously supported the IUC last year, this year, and now they are very interested in this study of the Brics Plus. This is really a topic that deserves and needs to be studied for a variety of reasons. Some of them are so banal that I'm not going to address them with you here. You are all part of our community, but master-minded and developed, which is a mental frame of mutual understanding and respect. This is a very important turning point in thinking international relationship, because, you know, capitalism has been based on international relationships that were dominated and still are dominated by power, by colonialism, and by attitudes of subordination. And this is what has created the mess that we are seeing around us in this current moment. It's not that it's especially novel that the international law is functioning poorly, but as bad as it has been working in the last couple of years or so, I think is a historical record. Because we still have the institutions, of international law that are supposed to be the one mediating the relationship of power between equal nations, but the institutions of international law simply don't work. And they don't work not just because of some problems that can be addressed by legal or technical engineering. It is not just the veto power of the permanent members in the Security Council that makes international law a dwarf in front of the forces of globalization that are going on now. Because even when the veto power has not been exercised, like in the case of the ceasefire on Gaza last spring, nothing happened anyway. It is not that international law is not talking at its highest possible level about the current situation, because the International Court of Justice which is actually in charge of the sources of international law, and therefore is the most important legal institution that we have in the world today, has repeatedly spoken with no success whatsoever. So this means that the problem is not just technically addressing a few issues here and there, it's a problem of mental attitude of the West towards the rest. And this is something that has been an issue for a long time. Many of the Brics countries, as we will see later, suffered harshly under colonization. Those that were not outright colonized, like Ethiopia or China, were anyway so much blackmailed by Western powers that they had to choose their future, taking into consideration pressures that were completely outside of what is acceptable in relationship that should be based on equal grounding. Let alone discussion about the relationship between Russia and the continent, Russia and the maritime power of England. Clearly, there are geopolitical situations that are extremely strong and that we can not certainly solve in this moment here, but that we can address as such. taking the lesson of scholarship and of comparative scholarship in particular. Comparative lawyers, at least since the work of the so-called structuralist, functionalist approach, have been trying very badly to avoid value judgments, to compare legal system from the perspective of one system teaching and preaching to the others. That has been, of course, the attitude of the West towards the rest for a long time. Think about the white man's burden of President Wilson, which brought, incidentally, the United States in World War I. The idea that, there is a context of production of law that can actually preach and teach to context of reception has been challenged very deeply in comparative scholarship, at least in the last 30 years, which is very, very good. This doesn't mean that comparative law has not remained a fundamentally colonialist or post-colonialist discipline. We still have, parts of the legacy of colonialism in the very framework of the comparativist approach, but certainly the effort has been done by the scholarly community to try to understand the rest in a perspective that is equal to our perspective of the West. Brics countries don't wait for the West. They have developed their own strategy and their own capacity of relate to each other, and this capacity is basically simple on the idea: understand each other, respect each other, and get some mutual benefits from respect of foreign sovereignty. That is to say, do not follow what in international law have become the most significant reason of its failure, that is the beginning, early in the last decade of the 21st century, of an attitude that there is such a thing as international human rights that is more powerful and more important in international relationships than the idea of equal sovereignty among member states. That vulnus that originated in the Balkan Wars is what has proved and created the current disaster we are living. The idea that an international community can self-appoint itself outside of any ritual to be the one that decides what are the human rights within in each country and what are the attitudes that should be kept within those countries. That is political intervention from the outside. Countries and policies, and you're talking with, who's talking to you is an old militant, are certainly unhappy very often about their government. This has nothing to do with the attitude that the international community should have about a country. I'm pretty sure that many Iranians are unhappy today of the Ayatollah regime. However, this does not justify and doesn't make less hideous the fact that a foreign alliance of lawlessness tries to intervene in internal affairs to substitute for local forces and local dialectics to introduce a universalist one. Okay? This approach is the one that we actually always used at the International University College. When we started with enterprise, I was dissatisfied with a lot of the issues and the problems of Western academia that is, so to say, the place, the crib in which the Western-centered thought and the attitude of positional superiority developed in the years. And I wanted to try to create a small place, a really small place, like an idea such as that of ecologists when they try to make a lake resurvive. How do you do that? You take a little bit, you protect it from bad infiltrations, and you see life returning and recovering in the lake. And then this little bit contaminates another little bit and another little bit and another little bit, and all of a sudden you have a very clean lake. I've seen that with my eyes in the beautiful Tahoe Lake at the border between California and Nevada that had a problem of pollution and was exactly repurified using a bottom-up strategy of bit by bit. And now it's one of the most beautiful lakes in the earth. Okay, so this is the idea. My idea was, let's try to create a little place in which we really have a complete freedom of expression. We really have complete respect of the position of each other. We really don't care where someone comes from. We are, in a way, blind from nationality. Nationality blind, we just try to contribute together to an understanding, a critical understanding of a reality that ultimately will go back to become how universities will believe should be. Okay? So that was the idea of the International University College. Now, this Brics report we are presenting today, of which I'm very proud, very, very grateful to all those that operated in it, Cristina Moschalaghe, to begin with. Then we have Martino Reviglio, Mariella Pitari, and I'm certainly forgetting Emanuele Ariano. I'm certainly forgetting others that have worked hard together with the students in the making of this report. Is, you know, a very early outcome of a process that we have carried out with this class this year in the advanced comparative law class, which I taught at the University of Torino with the International University College students. We devoted, you know, the course, each session, to deepening our understanding of the basics of the legal systems of the Brics. Because, you know, we lack the basis. The truth of the matter is that Western academia, people talk about Brics. Most people don't even know who the members are. Most people have no idea where the capital of the single member state should be. Most people have no idea of the basics of the political, legal, institutional, and cultural system of those countries. The level of ignorance, and I'm not talking about people's ignorance in the street, I'm talking about ignorance among intellectuals, pundits, journalists about these things is quite appalling. Yet, you know, all these countries have legal systems that are worth understanding and studying in their own terms, in relationship with the local economic and political condition of the place, to try to get at least a map of what we have out there that we call the Brics plus political economy. That is to say, what are the conditions of the legal system that determine and may determine the possibilities of Brics to thrive as a future alliance, integrating itself away from being just the relationship between strong executives of the different countries into an actual institutional system that learns the lessons from other experiences that occurred before, that maybe were successful and maybe failed according to how we interpret it, but a path that the BRIC countries are entitled completely to walk by themselves, and in which is not matter of nationalism, is matter of creating the best possible legal order for everybody. I was deeply impressed, I must say, last September when I traveled to China on invitation of my great friend Liu. I was greatly impressed by one thing among the many that impressed me: the capacity of the Chinese people to select the best of their society to do the tasks, and the following respect of the ordinary people for the leadership, because people know that those who reach certain points in the echelon of honors and in the social hierarchy arrive there because they are better. This is the complete opposite that what I have experienced in my own Italy. We have everybody who has a certain age, and I'm 64 by now, knows very well that those that were interested in politics and had political careers in this country of my generation were probably the worst one within our universities and courses of studies, because we do not know how to select the political class. And the result of not knowing how to select the political class outside of, fictitious, contentious elections that are ways in which capital contaminates the political system seems to be one of the worst issues that we have to explore in the West, and that we should take care of before going to say to the rest how they should do things, who is a democracy and who is not a democracy, as in the the normal narrative. Okay? So I was deeply impressed by that, and I think that that is the attitude that the Brics should develop and share. Not a legal system that is in the service of one or the other, but a concrete and serious veil of ignorance. A legal system that can work in the interest of everybody considered and understood as peers, no matter where you are in that particular scheme in this particular moment, but the best intellectuals of each country, the best legal scholars, the best people, the best politicians, the best people that are actually capable of saying something smart about the law should join together, discuss about the issues, and make proposals that are blind in the sense of having a long-term vision, but not a vision to the interest of the single specific country of the Brics itself. On that, we can contribute. On that, we can, as a small institutional as a small institution, together with other bigger ones, as legal scholars, as a political economists of law, I believe to that we can contribute. And actually, we must contribute. Because if we do not do that, the result is going to be a chaos of lawlessness that I'm sure that we are not going to be able to entirely avoid, but at least we can put on the table some recipes to at least steer in a different direction. And over time, this role has been played. In the toughest moments of the Cold War, right after the missile crisis of 1962, there was a program that was launched at the University College of London together with the Moscow Academy of Science that was run by Jeffrey Hazard from the United States, that was actually the only place in which the leading scholars, both of Soviet Union and of the West, were able to meet together and to discuss about the law, to discuss about legal innovation, to discuss about the ways in which a society should be organized to reach some standards of decency and some responsibility in front of its members. So I think there is a big necessity of this kind of work. Now, the report we are presenting here, and of course we are presenting this in a cadre that I will express you something later, of honoring Professor Mangabeira Unger from Brazil, but the report that we are presenting here are actually reports on 8 out of the 10 Brics Plus systems. We're just missing, because of lack of connection at this point, Indonesia and United Arab Emirates, but we have all the other countries that we have explored with a common methodological approach. The methodological approach is to try to locate this country within a taxonomy which is new, which is non-ethnocentric, and that tries to look at each system as a wave of different layers, developing one after each other in a very long and respectful human history of each single one of these countries that has generated the political and legal mentality of that special country we are considering. Because this legal and political mentality, that is to say the approach of the intellectuals and of the elites about the law in each legal system, matters a lot in the kind of enterprise we are trying to set on. And we have seen a variety of things just by studying and comparing this system. You know, usually comparative law compares Germany with the United States, with France, with Italy. There is some area studies here and there, but there is no attempt so far to do core comparison within countries that don't belong to the Western legal tradition, where actually countries of the Western legal tradition are not present, which is very, very interesting of the Brics condition. And so you regard the ideas of comparative law in that kind of spectrum, which is the spectrum that the IUC is anthropologically and sociologically here because of the provenience of all you guys. If you regard this country within that spectrum, you start to see things that are quite remarkable just for the fact of looking them together as a single whole made of different parts, each one having its own dignity. First of all, we see one thing, that the civil law common law opposition is actually a legacy of colonialism and should be rejected. We should not approach law and political economy of law in the BRICS by being obsessed of seeing whether that country comes from the civil law or the common law tradition. Simply, it doesn't matter. There are other kind of forces, other kind of cultural aspects that matter much more in trying to understand that. Therefore, we need new taxonomies, and I had suggested one, that the one we have used, to look at law as an aggregate of layers in which the professional layers is only one of the layers that are involved, and we've been outlining the system from that particular perspective. And in doing those kind of observations, we have seen that the journey that waits for us is and can be pretty long, but we can already have on the table certain kind of commonalities that emerge just by looking at the layered history, economic and legal, of each country. Those countries all have today, in my opinion, as opposed to the West, one commonality. First of all, they have a one bully they suffered under. So there is a clear contentious position of the rest towards the West. We should not fall in the harmony rhetoric. We cannot really understand the present without considering a past and the present of dramatic suffering and injustice that was generated by the global North to the global South. We have to look at that, understand it, acknowledge it, and try to make good of it with an open mind. This doesn't mean that we have to judge the behavior of our ancestors with the very values that we have today. That would be woke stupidity, but we have any way to understand and look at the history and historical responsibilities as they matter today and try to address them. Believing that they don't exist, believing that the West and the rule of law was such a gift of the West to the rest is mere bourgeois rhetoric, and also has to be kicked out of the field of inquiry if we want to be any serious in this matter. And then we'll see another thing that is very interesting, that the tremendous effort of the West and of capitalism, let's call it in the same way, to expand, to colonize, to develop outside and find always new markets, in the traditional analysis, has generated strategies of divide and rule that are responsible of much what is going on now, and that can be relevant also in the understanding of the BRICS. The BRICS does not share a common international and political vision. We certainly share the bully, but the attitude within the BRICS is very different. There are countries such as China and Russia that appear to be trying to develop something that is genuinely alternative, that is genuinely trying to substitute an hegemony, a new hegemony, for a previous one. And when I talk about hegemony, I talk about something that is, in Gramscian terms, much better than brutal display of power. Hegemony has a component of consent and a component of ideology, if you want, a component of hypocrisy, which is absolutely necessary if we want to create an international legal order that works. The substitution of the declining American hegemony with a new one is the real stake of the moment in international geopolitics. This means something from the point of view of our report. We're not considering this report as, mere exercises of law in context. It's not just looking at the law in the local conditions and being nice and respectful of the local conditions. It is about looking law within a geopolitical attitude. in which we are able to look at the dynamics of the present, the power structures that determine the present, in a perspective that determine how the legal system play and how they can adapt to the circumstances, maybe within the political law layer, maybe within the professional law one, maybe within the traditional law one, but in a way that is actually going in a direction that we still have to understand. There are other countries within the BRICS that certainly do not share the same hope, perhaps of China and Russia, to be creating something counter-hegemonic that ultimately becomes a model for the world. So countries such as India, for example, or Egypt, are much more probably into the condition of trying to maintain the BRICS as more of an economic than a political enterprise because of keeping good relationship with the United States and Western power. That is a genuine dialectic. That is not the dialectic in which, as scholars, we should put our nose in. We should maintain it present in our background. We should describe the forces that are at play. We should make predictions if we want to, but we cannot try to impose our vision of how we like the BRICS to become as something that might be likely to happen. It's very important in scholarship never to confuse your dreams with the reality, never to describe as something that is out there what you desire should be out there. You can do that, but that becomes, kind of maybe useless and visionary. We have to maintain the material conditions always present. Now, those countries, however, have one commonality in positive, I think. And this is something that seems to me is emerging from our reports in the long history that we have surveyed, which is the fact that the political system in every one of the BRICS countries has been capable to maintain some control on the private capitalist sector. In other words, the relationship between politics and law and politics and economy, which in the United States and Western world has been completely subverted by neoliberalism in a domination of the economic and especially the corporate sector on the political process through a variety of strategy, has not occurred, I would say, yet in the BRICS context. There is a big tension, I think, and a big capacity so far of governments to control the economy. We see that in China, very impressively. We see that to a lesser extent in Russia. We see that in Brazil. We see that more or less in different places, but we still have the possibility of a political economy which is public in its, understanding. It is not just the mirror of private economic forces developing the policy of a country. This is the commonalities that I think we should expand on, understand how a political economy system can work with a powerful center without being completely dependent on who is the guy in power in this particular moment, because of course BRICS require some level of institutional coherence that has to be maintained, as much as, let's say it very clearly, as much as hegemony requires a modicum of coherence. I'm not saying that hypocrisy is bad in international relationships, but a modicum of coherence is very important. And this modicum of coherence is what the West has lost in the last 25 years after the September 11 attacks in the United States. The preaching about the rule of law in countries that became more and more authoritarian, belligerent, and obscurantist is something that cannot be bared and cannot be looked without saying the king is naked from an institution like ours. And you will see, if you read these reports, that we are not taking sides. We are not rooting for this or that other countries. We have our share of critiques, very gentle all the time about the systems in a variety of perspectives, because we believe that critique is important, and critiques can be rebutted. This is a very early draft. This is what the class of 2025, together with our faculty, has been capable to offer to this inaugural path that I hope is going to be long and successful of the BRICS Plus Forum. Now, we are convening here, however, also to honor a great master. Professor Mangabeira Unger was picked, as the keynote addresser of today and as the honored figure in this event for a variety of reasons. First of all, because his scholarship is terrific and he is one of the most important, I believe, lefty thinkers that are in the world out there today. His theories of knowledge, knowledge and politics, his capacity to witness the transformation of capitalism in the current phase, the information economy, all of that is beyond critique. Professor Unger also is Brazilian. He was the youngest law professor from from Harvard Law School. He was appointed there as a full professor before he turned 30 years old, which is remarkable, coming from Brazil. And he remained always a Brazilian. He was involved in local politics with the Lula administration at the beginning. He was, you know, a towering figure in the Brazilian culture, and many of our Brazilian friends actually came here hoping to have a chance to see him in person. Unfortunately, age is passing also for Professor Unger, and also he decided that it was not, after he had a long journey before, he's not coming. We will have him now with a very interesting video, and he will participating in the discussion about the future of Brics this afternoon. Professor Unger has, you will see, I don't want to spoil the vision, I think has and gives us a good framework of analysis. He is not only a cosmopolitan thinker, but he is also a genuine social theorist. That is to say, he doesn't stick into, you know, law as positivism. He doesn't stick into some sort of law in context, but he develops a full-fledged theory of social institutions. That is what we need at this point, because law is one of the players of this game and is not the only one. And who is talking to is someone that devoted 40 plus years of his life to the study of law. So we need also as lawyers, you know, to maintain some sense of proportion of what we can do and we can contribute and what we cannot, especially in a moment of great technological transformation like the present.